Would that be a fair assessment?
Chair, can I indicate that we never ever got to the dedicated courts? We did, there was an exercise, a series of meetings, a whole exercise that was conducted, but we never got to the issue of the dedicated courts. What the prosecutors did do is try and have those matters prioritized on the court rolls that they were operating from, so that we could see the better finalization of the cases. Thank you.
We were going to get to that later, but maybe you could explain to the Commission what the investigations into a dedicated court revealed and why you never got there.
Thank you, Council. Chairperson, at the time when there was this talk about the dedicated courts, and if my memory serves me correct, although I cannot be so specific, was that there was a real outcall from the time when I came in for a dedicated court. So basically what happened is that, especially after the meeting of 23 August, we then set out to look for a dedicated court, and we went to the acting regional court president at that time and spoke to him. But we realized that we couldn't speak without the regional head for the Department of Justice. So what we then did is we had the meeting postponed. And during the time when we had the meeting postponed, then we had the correspondence of the Minister Lamola come in about the dedicated courts. And that was the 10th of September, if I look into the record. And on the 12th of September, we then had a meeting with the regional head together with the acting regional court president at that time to discuss the dedicated courts. And this was also with my team that I was with. Chairperson, there were a series of meetings thereafter. And one will note, if it ever comes, is that there was a court, one court was identified, but there were security issues in regards to that court. So we had to go back to the drawing board. And then we identified different areas or different centers. And it was 3 basic centers. It was Richards Bay, it was Durban, and then it was Pietermaritzburg. And the reason for that was that we would be bringing the cases from the outer lying areas to the nearest center to deal with those matters. And Chairperson, we went deeper down with that analysis. We started to look at, okay, now let's look at the cases that we've got. And we found that some of the cases were, many, let me put it that way, were already on the court roll for trial. Now, witnesses have been subpoenaed, they need to go to that court. You're now just disorganizing everything in regards to those court rolls, because remember, it's already a set court roll for that court. But further than that, Chairperson, that something that also was a bit of a concern for us was that you've got a matter coming from, let's say, Engwavuma or Jozini, and you're bringing it to Richards Bay, which is nearly, say, between 200 to 300 kilometers. You're taking away a matter from the community where the matter was committed. The community also wants to listen to the matter. Further than that is that you've also got the family of the deceased that also wants to come in and listen to the matter in court. Now, there's no witness fees to pay for all these people that need to come in. So that was also something that we had to discuss. And that is the reason why at the end we just decided, you know, the matters are there on the court roll. They are continuing. It's not as if we did not go back and look at or look into the issue of a dedicated court, but just the logistics and everything surrounding the logistics was just not working out for us.
Thanks, Advocate Harrison. Can I take you back to your letter now? And we've essentially reached your conclusion. And can I ask you actually to read into the record what the conclusion of your letter to Lieutenant General Mkhwanazi?
It is requested that you assist with providing my office with a response regarding whether the SAPS political task team still exists. The dedicated capacity needs to respond to the dedicated task team. If there is no dedicated prosecutorial capacity, will be dissolved, and all new cases will have to be reported to the Chief Prosecutor. 26. It has its own priorities as per the NPS AOP. As we are all aware, organized crime has become the new focus or priority, and this office needs to plan. I am unfortunately not able to complete the planning because the issue regarding the existence of the task team has not been communicated. At this stage, the only information which one has is that in the media. Your urgent response to the above issue will be appreciated, and signed off by myself.
Thank you. And is there anything you want to say in, I mean, it speaks, says a lot itself, but is there anything you want to say in amplification of that conclusion?
Chairperson, the only thing is that, you know, you've dedicated the work of the task team, and you've given I've given the dedicated team from the organized crime component. And we all know that what is going on at the present moment, as it's 2025, regarding the issue of organized crime. If you read in any media platform, you'll always find something about organized crime. And the NPA has got its own strategies and action plans as to how we need to approach the work. And I was finding that I'm unable to finalize the KZN annual operation plan because there's no finality regarding the existence or non-existence of the political task team, which would then make me, it would have an input regarding the KZN plan. Thank you, Chair.
Mr. Chairperson, before you leave this letter, Advocate Harrison, if you look at page 196, that letter, and you've skipped parts, I just want to clarify that I understand them correctly just from my reading. In the third paragraph, you say, I also wish to bring to your attention a correspondence with the Minister of Police, and that correspondence, and this is to the National Director of Public Prosecutions, and that correspondence is the 24th of May. We discussed the meeting of the 5th of August 2019. And I think in your explanation of that paragraph, you say Minister Lamola was also present at this meeting. What does this mean? In May 2019, you speak of Minister Cele, and in the next paragraph, in August, you reference Minister Lamola. Had there at this point been a change, or is it a mistake, your reference to Lamola?
Okay. Commissioner, in 2024, in May 2024, it was Mr.
2019.
In May 2019, it was the Minister of Police at the time, Mr. Cele, who had written to the National Director regarding the coordination process.
Yes.
And then there were a series of meetings. And when I say a series, there were lots of meetings at this stage. Then you have the meeting of 5, August 2019. And I think I indicated somewhere, I can't remember all the dignitaries that were there, but it was the National Commissioner of the South African Police was there. I can't remember whether it was Mr. Cele at that time or Sitole, but it was one of the national commissioners. But indicating that they were there, and if you look at the correspondence, as I said, from the Minister Lamola, he clearly was present at that meeting of 5 August. So it was me trying to explain or show the series of events that had taken place for us to get to the coordination process at the time.
All right. So what I wanted to clarify was, in August 2019, the minister at that time was Minister Lamola. Oh, sorry, I'm making a mistake, actually. Minister of Lamola was Justice, right?
Yes.
Yes, and Cele was Police.
Yes.
My mistake, I don't mean to confuse you. A different point about it, though. In May 2019 and in August 2019, you had both Minister of Police and Minister of Justice concerned about political killings at that point and requiring them to be prioritized with dedicated resources.
That is correct, Commissioner.
And that's because at that point it was an issue, political killings in 2019.
At that point, it was an issue.
Thank you. Thank you, Mr. Chairperson.
Thank you, Commissioner. Maybe if we can now go to the annexures. And if we can take them chronologically, can we start with Annexure B, which is at page 202 of the MK12 bundle, and it's the letter from Minister Cele, and it's 19 May 2019. And before we actually look at the annexure, can I take you to an email on page 251 of that bundle? And is this the email under which you received the copy of Minister Cele's letter?
Yes, Council, that is the email that forwarded me the correspondence that is on page 202. And the email is dated 3 June, and it was received from the office of Advocate Batoy.
Then if we go back to the letter itself on page 202, in paragraphs 1 and paragraphs 2, the letter explains its purpose and sets out its background. And then in paragraph 3, the minister identifies challenges. And there are a series of challenges that the minister identifies. Can you take each of those challenges and just respond to them as whether they were challenges, whether you accept that they were challenges, and later deal with how you responded to these challenges?
Thank you, Council. The first challenge there was the Section 204 witnesses killed while in the witness protection program. I think it's only one case that was reported where this had happened, but it had an impact on the other cases. So if you look at it, one case it's recorded there, the station and case number, but it impacted on these other two, meaning that that witness was probably a potential 204 witness in the other two cases. Do you see that, Council?
I do, yes.
Yes. So, and it was indicated that he was killed whilst in the witness protection program. And the witness protection program is something that it fell within the space of the NPA, but there was a suggestion that came from the political task team who responded that maybe they needed to get police officers or security to deal or to assist with that program, especially for their witnesses. Then the second one is key witnesses.
Sorry, Advocate Harrison, before we leave the first one, just for the benefit of the public, can you explain what a Section 204 witness is?
It's an accomplice witness. That is, I don't know if you want me to go deeper than accomplice.
I think accomplice witness should be good enough.
Okay, thank you. And then 3.2, key witnesses killed outside the witness protection program. It was justified by witnesses on the cases mentioned in the table below were offered with witness protection program but declined. Chairperson, this is not unusual, where witnesses are given an opportunity or are presented with the option of going on to witness protection and they decline the witness protection. If they are thereafter killed while outside the witness protection, obviously we can do nothing about it. We've offered them the services. Then Section 204, witnesses turned against the state, witnesses who abandoned witness protection. Let's differentiate, or let's try and unpack the two of those. A 204 witness turned against the state would be a witness where he has produced a 204 witness statement, and then he decides that he's no longer going to testify for the state. And then you have a witness who has abandoned the witness protection program, is a witness who was on the witness protection program and then decided to walk off the witness protection program. So that is how I would unpack that challenge. And that is also not uncommon. In cases we have this happen, where witnesses are taken to witness protection and just decide, I don't want to anymore. And I would like the Commission to take this into account. When you put a person in